Who hasn't heard of international sanctions these days? Anyone who hasn't has probably avoided global news for the past decade. The annexation of Crimea by the Russian Federation triggered an avalanche of reports, analyses, and commentaries about the sanctions imposed on Moscow. Tens of thousands of articles appeared in the international press, in academic centers, and in political think tanks. After February 2022, that number increased more than fivefold. International sanctions have become not only instruments of foreign policy, but also products of media consumption. This media explosion confirms something paradoxical. It confirms the urgency of a sober reflection on the concept of legal sanction in public international law. Because beneath the headlines lies a deeper problem. What are sanctions legally speaking? Public international law has long struggled to defend its own status as law. From John Austin, who believed that international law had not progressed beyond public morality, to Hans Morgenthau, who described it as a primitive kind of law, skepticism has shaped the debate for centuries. Even today, echoes of that skepticism remain visible in international relations theory and geopolitical analysis. However, modern legal doctrine has largely settled the question. International law is recognized as a distinct and genuine branch of law. And yet, the skeptics' central argument persists. International law, they say, cannot be a true legal order as long as it lacks sanctions. Others concede that sanctions exist, but argue they apply only to small states, while great powers remain untouchable. This conclusion, however, is based on confusion. The degree of compliance with a rule does not determine its legal nature. It determines only its social effectiveness. If violations negated legal character, criminal law would not exist either. More importantly, the claim that international law lacks sanctions is simply false. What is missing is not the sanction. What is missing is a proper understanding of how sanction operates in a legal order without a sovereign. In international law, the word sanction carries an aura of legal certainty. Yet, paradoxically, it has no formal definition in any foundational legal instrument. Doctrine is therefore left to reconstruct its meaning. Scholars have borrowed terms from practice: restrictive measures, countermeasures, reprisals, embargoes, economic blockades, boycotts, smart sanctions. But instead of clarifying, this proliferation of terminology often blurs distinctions. Legal language merges with political vocabulary, moral rhetoric enters the discussion, and conceptual precision becomes harder to maintain. So the essential question remains: which of these measures truly qualify as legal sanctions under contemporary international law? The answer does not lie in media discourse, nor in political speeches. It lies in doctrine, in the systematic reconstruction of legal categories. Strictly speaking, a legal sanction is the reaction of a legal order to the violation of one of its norms. Its function is restorative. It seeks to correct unlawful conduct or eliminate its consequences. In domestic systems, this mechanism is visible and institutionalized. Sanctions are embedded in the norm itself. They produce immediate and tangible effects. Public international law operates differently. It is a system of coordination among sovereign entities. It lacks a central authority, and therefore the mechanism of sanction is less visible. But it exists. It functions through the institution of international responsibility. This institution, codified by the International Law Commission and reinforced by international jurisprudence, expresses a simple idea. The legal order defends itself. Sanctions manifest through countermeasures, through reprisals, through acts of retorsion, through non-recognition of unlawful situations, through the nullity of treaties violating jus cogens, through international criminal responsibility. Sanction is not absent. It is structural. The problem arises when sanction becomes indistinguishable from strategy. In strict legal terms, a sanction presupposes a breach of law, a competent authority establishing it, a proportional response. In other words, it is a reaction of the legal order itself. However, many contemporary sanctions are unilateral political decisions. They are expressions of power. Legal language is often used to legitimize these decisions. And when that happens, law becomes a vehicle for political will. The distinction between legal sanction and political coercion becomes blurred. Beyond legal theory, economic sanctions derive their strength from financial reality. The global dominance of the US dollar, control over payment systems, access to international financial infrastructure. To be excluded from these systems is to face economic suffocation. Sanctions travel through financial arteries. They are enabled by monetary architecture. In this sense, Western economic sanctions are not merely legal phenomena. They are also monetary phenomena. Law rides on currency, and currency reflects geopolitical power. Unilateral sanctions not authorized by the UN Security Council must comply with the law of state responsibility. If they fail to satisfy the conditions of lawful countermeasures, they may themselves constitute internationally wrongful acts. Retorsion remains lawful as long as it stays within legal limits. Countermeasures are lawful only if they respect proportionality and other conditions established in general international law. The 1965 UN Declaration on the Inadmissibility of Intervention clearly states, no state may use economic or political measures to coerce another state into subordinating its sovereign rights. Similar principles appear in other international instruments. This reflects a normative consensus. Unilateral coercive economic measures often stand in tension with the principles of sovereignty and sovereign equality. The paradox of international sanctions lies in interpretation. When states bend legal norms to serve temporary interests, they create precedents. Those precedents are later reused. Strategic interpretations can gradually solidify into custom. International law does not collapse because it lacks sanctions. It weakens when sanctions are politically instrumentalized. Every exception justified in the name of necessity may eventually return as a weapon of legitimacy in the hands of others. Perhaps the greatest danger to the international legal order is not disorder itself. It is the normalization of convenient interpretation. And that is the lesson international law still struggles to learn. If you found this breakdown useful, subscribe to Geopolitics Row. This channel is about explaining geopolitics as systems, not as slogans.